Let's dive right into this detailed visual explainer of the Maria da Penha Law. Today, we're taking some pretty dense legal text and translating it into an accessible, empowering guide on rights and protections. This specific Brazilian law is recognized all over the globe as a massive landmark for combating domestic violence. So we're going to jump straight into the raw official legal text itself to pull out exactly what you need to know.
Here is our roadmap for today. We're breaking this down into 5 key parts: what the law actually is, the specific forms of violence it covers, how police assistance works, the urgent protective measures available, and finally, the real consequences for the aggressor.
All right, starting with part 1, what is the law? Let's look at the foundation.
You know, a lot of folks assume criminal law is just about punishment after the fact, right? But Article 2 flips that on its head and establishes a purely preventative foundation. It dictates that living without violence and actively preserving physical and mental health isn't just some hopeful, far-off goal. It is an undeniable, fundamental human right for every single woman. Basically, it sets the legal baseline that violence is a direct violation of human rights.
And to actually enforce this, Article 8 doesn't just tell the police, hey, go handle it. It mandates a highly integrated approach. The law requires the judiciary, police, health services, and social assistance to work together seamlessly. It even goes as far as requiring education systems to teach human rights and gender equity. The whole idea is to build a massive web of support rather than just having isolated departments. Moving on to part 2, the forms of violence. And we're going way beyond just the physical.
A huge misconception is that violence is only legally actionable if it leaves a physical mark. But, as we see here in Article 5, the law officially defines a much broader scope. Notice the key parameters. It legally recognizes harm, whether it happens in a shared home, among family members, or really within any intimate relationship, even if the victim and aggressor don't actually live together. And crucially, it covers both harmful actions and omissions.
So the law enumerates 6 distinct forms of violence. We've got physical, psychological, and sexual, which you might already expect. But look closely at these last 3. Patrimonial violence, that literally means destroying a victim's phone, holding onto her personal documents, or controlling her bank accounts. Moral violence covers things like slander and defamation. And then there's the newest addition, vicarious violence, which is incredibly profound. This recognizes that harming a child, a dependent, or even a family pet as a way to inflict psychological pain on the woman is a strict, prosecutable legal violation.
Okay, Section 3, Police Care and Assistance. Let's talk about immediate action.
Taking this from awareness to real-world application, Article 12 outlines a very strict 3-step procedure that authorities are legally bound to follow. It completely removes the ambiguity. Police must take the report, they must facilitate medical exams, and, this is absolutely crucial, they have a strict 48-hour window to escalate the request for urgent protective measures to a judge. The clock starts ticking immediately.
Now, to ensure the justice system actually helps rather than traumatizes, the law was updated with Article 10A. It explicitly guarantees that victims receive specialized, humane care. It literally mandates that victims shouldn't be subjected to repetitive questioning about their private lives across a bunch of different departments, which prevents what we call re-victimization. Having trained, preferably female staff ensures a genuinely safe environment for disclosure.
This next section cements that urgency even further. If you look at Clause VA, it compels police to not just passively sit there and take a report, but to actively investigate immediate risks. The police are legally required to verify if the aggressor possesses a registered firearm, and if they do, the police must document it and notify the firearms registry right away. It's an incredibly active threat reduction protocol.
Next up, Section 4, Urgent Protective Measures. Once that police report is forwarded, the power shifts directly to the judiciary. And these urgent protective measures, they work in 2 simultaneous directions, kind of like a two-way street. On one side, we see logistical and financial lifelines purely for the victim, things like securing rent assistance, priority school transfers for kids, and safe removal from the home. On the other side, the law drops the hammer on the aggressor, forcing them out of the house, immediately suspending firearms, and strictly enforcing distance through electronic monitoring.
Looking at these original texts and the later amendments, we're seeing a fascinating legal evolution. The law has been continuously sharpened so that judges can apply these urgent measures based solely on the victim's police statement. Think about that. There's absolutely no requirement to wait for a lengthy trial, a final conviction, or some formal hearing with the aggressor before these safety measures are deployed.
The big takeaway here is right in Article 19, which basically dictates that bureaucracy cannot stand in the way of safety. These protections are immediate. They don't depend on a broader criminal case moving forward, and they have no hard expiration date. They literally remain in force for as long as the victim remains at risk.
Finally, Section 5, Consequences. Let's look at aggressor accountability.
As we all know, a law is only as strong as its enforcement. And this legislation entirely eradicates the historical leniency we used to see surrounding domestic violence. Decades ago, abusers might have literally just paid a small fine or donated a basic food basket to a charity as their punishment. Well, Article 17 strictly forbids that now. Plus, the aggressor can be put under preventive arrest at any phase of the process, and, get this, they must financially reimburse the public health system for the victim's medical care and cover the costs of their own electronic monitoring.
Then, Article 24A builds this ultimate safety net by introducing a crucial legal shift. Before this, breaking a restraining order was often just treated as a generic civil disobedience issue. Now, this article criminalizes the act of simply ignoring a judge's protective measure, completely independent of any other violence committed. It instantly triggers a brand new, separate crime.
Disobeying that protective measure now carries a mandatory penalty of 2 to 5 years in prison. And if an aggressor tries to tamper with or remove their electronic monitoring ankle bracelet without judicial permission, that prison sentence automatically gets bumped up by up to half. The law is clearly designed with real teeth to keep abusers contained.
As this explainer shows, the legal framework we've looked at today is incredibly robust, and it's constantly evolving to meet modern challenges. The text itself provides powerful, very real tools to dismantle abuse. But a law on paper only works if people know how to use it, right? Which leaves us with a really important question to think about. Knowing all these extensive rights exist, how can we collectively ensure these protections are communicated, understood, and truly accessible to every single person who needs them? Thank you so much for exploring this vital topic with me today. Keep learning and stay curious.